I think many questions I was just listening to in earlier presentations. I think some doubts have already been cleared. So we'll generally focus about what is there for the victim, what is there for the police, and what is there for the witnesses, what is there for the accused in the new criminal laws. And why do we call them victim centric laws? What are the provisions related to the victim which are not there in CRPC? What new powers do the police have acquired in the new laws which may empower them to do an effective investigation? What was not there in CRPC, which is there now in this new act, particularly the BNSS? That would be the focus of my talk. And I think some related things, and if time permits, then I'll go give you a very brief overview of the new Evidence Act, that is Bharatiya Sakshya Adhiniam. We'll straight come to the BNSS because of the paucity of time. Straight away, I'll go to the section 35, which I think all of you by now know very well. It is like the corresponding section in CRPC, section 41 and 41A. Both were very important sections because in 2009, when this particular section was amended, they divided the non-bailable offences into two categories: those which are punishable with 7 years or less and those which are punishable with more than 7 years. What was amended was that if you intend to arrest a person in a crime which was punishable with less than 7 years, you have to record your reasons. Unless there are justifiable reasons, you should not arrest. That was the mandate, and section 41A was added, where it was again mandated that if in all the clauses of section 41, there I think most of the people do make a mistake because they confuse section 41A in the sense that they think that 41A is applicable only in those cases where punishment is 7 years or less. I think that is the incorrect reading of the law because it says all those offences which are there in section 41, subsection 1 means including all the clauses. If your decision is not to arrest a person, then you must issue a notice. I think there was some misreading, miscommunication in our subconsciousness. We perhaps made this impression that in those cases only, we need to give a notice where the punishment is 7 years or less. And we should not arrest any person unless we first give this person a notice, because maybe the way we read the judgment of the apex court in Ernest Kumar versus State of Bihar in 2014. But the correct legal position is this, that if you have decided not to arrest, then you must give a notice. If you have decided to arrest for arresting a person, in fact, section 41A does not apply. You don't have to give any notice if you have decided to arrest. Only thing is, if the punishment is less than 7 years or 7 years, in that case, you should have justifiable reasons. You have to record your reasons in writing that though the punishment was 7 years or less, but you still felt that this person needs to be arrested. You will have to satisfy the court that when you take the person to the court, that on valid grounds only, we have arrested this person. So in this new section, the corresponding section 35, BNSS, all those changes have been incorporated. You can see that in section 35, subsection 3 to subsection 6. Earlier 41A has been reproduced as it is. Because here they say, where in section 35(1) above, decision is not to arrest, then you have to issue a notice to the person for appearance. And if that person appears, it is his duty to appear in response to this notice. And if that person appears, then you shall not arrest. Whereas what most of the police officers have been doing is that they first give a notice and then they arrest. Supreme Court, in another landmark judgment in the same subject, that is Sachendra Kumar Until versus CBI, have, I think, kind of questioned this practice. They have come down heavily. I think they have sought affidavits also from all the states where you are allowing such arrest after issuing the notice. So one is that there should be a very correct understanding and application of the new section 35. As far as the change in the new law is concerned, as was discussed just before, the charge is only this, that if you intend to arrest a person who is above 60 years of age, or who is infirm, not able, and not in all cases, only in those cases where the punishment is less than 3 years, only in those cases where the punishment is less than 3 years, then there is a new safeguard that has been introduced, or a new condition that has been introduced, is this, that you will require prior permission of an officer of the rank of DSP, DYSP, or above rank if you intend to arrest a person who is a senior citizen above 60 years of age, or who is infirm, but only in those cases where punishment is less than 3 years, not in other cases. So, these are the changes that have been made regarding powers of police to arrest. As far as the right of the arrested person are concerned, two important changes have been made. One is that when we arrest a person not in the presence of the family member or not from his place of residence, in that case we have to ask the person, whom do we inform about your arrest? As per the earlier provisions, that person either could name a family member, a relative, or a friend. Now they have added a fourth category. Now they say any person could be named by the accused person for providing information about arrest of the accused person. So it is now the discretion of the accused person, whomsoever he wants to be informed, will have to inform that person. Second thing now, which is I think the state government will have to take steps, because there is a mandate for the state government that the state government shall designate an officer who will not be of the rank below the rank of the assistant sub-inspector for every sub-police station and every district. What will be the duty of this officer? To collect information about all those who have been arrested in respect of a police station, in the police station, and in respect of the district, in the district, in the last 24 hours, and get this information displayed preferably by electronic means, digital display, at a place where people can easily access this information. And these are the people who have been arrested by either this police station or in this district in the last 24 hours. So this is the responsibility of the state government. That state government will have to issue a kind of notification where they shall designate officers of each police station for every district of the state. So this work will have to be done by the state government. However, as far as I know, I think from the state also this request has been made to the MHA that if it is amended, and instead of giving this responsibility to the state, if it is given to, I think, the police officers, because he is the best person to designate officers for the district also and for the police stations also, instead of giving this responsibility to the state. Practical issues. Now, every time there is a new officer who will be designated, then the state will have to issue a new notification. So, keeping in view these practical difficulties, I understand from my limited interaction and knowledge that many states have made a request to the MHA to please amend this and provide this power to the district SPs. Now, as far as empowering the police is concerned, one of the grievances of the police was that after the judgment of the Apex Court in Citizen for Democracy versus State of Assam case in 1995, Supreme Court placed a restriction on the use of handcuffs by the police whenever they would arrest a person, particularly in a serious offense. And what was mandated by Supreme Court in 1995 was that if you want to use handcuffs, first you obtain the permission of the court. So you have to make an application to the magisterial court, obtain the permission of your magistrate, then only you can use handcuffs. People started, like escaping from custody. People started taking police convoys, and like particularly where everyday people are taken from the prison to the court. Then for one person you have to deploy 4 or 5 or 6 people. In the new criminal laws, they have amended the corresponding section 43, and now they have restored this power of the police where they could use the handcuffs for arresting serious offenders. What is to be noted? The restoration is not blanket, nor that in every non-bailable offence you would be able to use handcuffs. They have specified the categories of arrested persons for arresting whom you can use handcuffs, and also for producing these arrested persons in court. Who are they? Who can be they? They have specified 3 categories of persons: those who are habitual or repeat offenders, or those who have history of escaping from custody, past history. And third category, I think, is the most important category over here, who has committed one or more of the 11 crimes. Which are those 11 crimes? Like organized crime, terrorist act, drug-related crime, illegal possession of arms and ammunition, murder, rape, acid attack, counterfeiting of coins and currency notes, human trafficking, sexual offences against children, and offences against the state. And the 11 crimes, if you want to arrest a wanted person, or if you have a past record of police custody or a judicial custody, and those whom you consider Those who qualify to be called habitual or repeat offenders, you don't need to ask the court to arrest them. You will be able to use handcuffs while arresting and producing such arrested person in court. Medical examination of the arrested person may be an important change. In the earlier law, that is CRPC, there was a provision that when you go to the medical jurist and make an application for the medical examination of such person, the application could be signed by not less than an officer of the rank of sub-inspector. So it doesn't have to be a sub-inspector. It can be an ASI, head constable, or even a constable. So the application need not be signed by an officer of the rank of sub-inspector. It can be signed by any officer. It has also been mandated in the new law for the medical jurist that they shall, without any delay, forward this medical examination report to the police officer. It doesn't have to be necessarily an officer of the rank of sub-inspector or above. State government has to play an important role only when this provision will come into effect. We all know that the police have to spend a lot of time and resources to implement summons warrant. We have to service summons which are issued by the court, and they are generally done physically by us. Therefore, it takes a lot of our energy, resources, time. So, what has been enabled? It's an enabling provision as far as the law is concerned, because it enables that now summons can be issued in electronic and digital form also by the courts. In digital form, it has been written that either by putting digital signature or by having an image of the court seal. It has also been mandated that in every police station and the court registrar who will maintain a register, all this information will maintain, which will enable issuance of summons in the electronic or digital form. Either the summons will have to have a digital signature of the magistrate of the court, or the officer who will be authorized to issue the summons by the court. Those summons which are bearing the image of the court seal. But when it comes to its service, they only mention summons bearing the image of the court seal. Here they seem to have forgotten to include digital signature. Then it says may also be served by electronic communication. Why I am particularly pointing this out? Because it is now for the state to point out, I think, these shortcomings. But more important is how such form and manner as the state government maybe rules provide. This is, I think, most important part of the subsection, because duties of the duties and onus is on state government. So whether the state has already initiated this exercise or not, that is, I think, for the state to introspect and take necessary action. Then, as per earlier laws, we could have a copy with any adult male member of that person's family. What has been changed in the new law is that this has been made gender neutral. It need not necessarily be an adult male member. It could be any adult member of the family. What shall be considered as proof of service of electronic summons by the courts? For that, they have written in this section 70 that the proof would be like if you take a copy and provide that copy to the court. So that will be treated as a proof. So they have written that very important. The most important two things are like this. One is that you can issue the summons in digital or electronic form, and you can also get it serviced in digital or electronic form. But how will you get it done? What will be the procedure? This will be decided by the state government. Last is very important, section 71. It says because now courts also have the necessary information. So why it has to be routed through the police? Why the police has to act as an intermediary, particularly for servicing the summons? So the last section 71 says courts can also directly service summons by electronic communication. So I think if we promote this, then it will save a lot of the resources of the police as to today spend on servicing of summons. So this is very important. Proclaimed offender and attachment of property of the proclaimed offender who flee the country and go abroad. What is the important change in this? One is that change in the definition of the proclaimed offender. That I think has to be noted very carefully. Because in the earlier laws, there is a section 82 subsection 4 CRPC. If we look at the definition of the proclaimed offender, we find that only certain persons, absconders, who were wanted in one of the 19 crimes listed in that subsection. And as you can see on the screen, all these 19 crimes are IPC offences, not of any special act, only IPC offences. And here also, if you look at sections, you find many important sections missing out there. Say for example, 376 offence of rape is not there. To address this anomaly, what has been improved in the new law? They have changed the definition of proclaimed offender. Instead of linking it to individual offences, now they have linked it to the punishment. All those absconders who are wanted in any offence, either of BNS or any other law. That is again very important to be noted, because earlier all the offences were of IPC. So they have said that not only BNS but also any other law of any special act in which punishment is 10 years or more, or life or death. So the definition has now been linked to the punishment, not to the specific sections of the particular law. That is, I think, very, very important change. Another change, they have introduced a new section 86 in which it is stated that if a proclaimed offender, if that person flees this country, goes abroad, and there he uses the proceeds of the crime, then he is able to invest the proceeds of crime in that foreign country, then the court of our country will be able to issue on our request. That is on the request of police, superintendent of police or commissioner of police. On the request of the police, the court will issue a letter of request or a letter of entry, LR, letter rogatory, which is popularly called. He will send it to the corresponding court there and will request them to identify the proceeds of crime properties, attach them, forfeit them. Obviously, in due process of law has to be followed, which generally we already know. Secondly, this is a very important section because, as we know, it is a matter of empowering the police. It's a matter of empowering the investigating officer. Until now, 91 CRPC notices that we used to give to any person. What could we demand from them? One, we could demand documents or we could demand material things which were in possession of the person. And we thought that those documents or material things were of relevance to the issue we were investigating. The corresponding section 94 BNSS, what they have added in addition to the documents or material objects, what has been added is that now you will also be able to demand the production of electronic evidence, which includes electronic communication, including communication devices, which are likely to contain digital evidence. If we read this properly, then we will see that any type of electronic or digital evidence in any form, whether it has been stored in your email, whether it has been stored in your mobile or any device, pen drive or other mediums of storage, or even if it is stored in a person's cloud, and also can be demanded by the investigating officer by issuing a notice under 94 BNSS. So the amendment now empowers the investigating officer to collect electronic or digital evidence in possession of any person. This is an important change that has been made in the particular section. Now this is, I think, the most talked about and discussed and debated section. I don't need to tell you much about what has been proposed in that section. This is the important change that has been made in this particular section. Now this is, I think, the most talked about and discussed and debated section. So I don't need to tell you much about what has been proposed in the section. You already started that because this is one provision which came into effect from 1st July 2024 in all the new FIRs that you have registered, all the new FIRs, not in the previous FIRs. Those FIRs which are registered before 1st of July, a new fact comes up, a new place is found, a new accusation comes up. And if we are searching today, then please note that the provision of the section 105 BNSS would apply only on the new FIRs, not on the earlier pending FIRs. This is one thing. What issues are coming in this? What recording should be done? Because what they have written here, the process of conducting search of a place, I think that has added to our woes. Because it practically covers everything that you do once you enter the premises. Otherwise, the remaining three things can be understood. The process of taking possession of any property, article or a thing, because it will be limited. When you start doing search, at that time, you have to record what items, what objects, what documents you are taking from here. In the same way, the properties that you will search, you will make a list of them. So the process of making a list has to be videographed. It is also completely manageable. In the same way, when that list will be signed by the witnesses, I don't think it will take much time. And it will be very easy to do the recording of this process. The problem is the first one, where they say the process of conducting such of a place. But one thing to note in this, that is my own observation. Some people may have a different view on that one. Note that in section 105, which search is he talking about? Which search is he talking about? In that, he is talking about two types of search. If you read it properly, because in the opening sentence itself, he says, search is done under this chapter. So many people are confused that if I am standing in the middle of the road, suddenly a suspicious vehicle comes, I have to search the vehicle. So do I need to do videography under section 105? Because I am going to conduct search of the vehicle. Certainly not. Because that will not be considered as a search under this chapter. And what is the second one? 185 BNSS. So he is talking about two types of search. If you strictly ask me, it has nothing to do with the examination of the scene of crime. First of all, the state government will have to notify. From that day, that notice will be applicable for what? Only in those offences where the punishment is more than 7 years, and it will be made mandatory by the state government by notification. That now from this day onwards, you will have to mandatorily take a forensic experts along with the team for the purpose of collecting forensic evidence from the scene of crime. So what is mandated for videography? When this forensic expert will go on the spot and he will go on the spot to collect the evidence, you have to videograph that process. That will also be mandatory the day the state government will notify it. And for that, the state government has been given a 5-year window. So first of all, I do not think it is right to link the examination of the scene of crime to section 105. Secondly, people have a doubt in this. The doubt was that, like earlier, there was this section 27 of the Indian Evidence Act in which we take information from the accused, and on the statement of the accused we go and recover some evidence from some place. Whether those recoveries will also be covered under section 105. Therefore, when we do effect recovery on the information of the accused, either given under section 27 of the Indian Evidence Act and there is a corresponding section 23 of the BSA, then should we consider it as the truth of section 105 and record it in this way or not? If you ask me, certainly not. By the way, if you do videography voluntarily, that's a different matter. Law does not bar, law does not prohibit you to do. For your own safety, for your own security, for your own directions, that is totally understood. But what I am trying to impress upon, that as far as the new law is concerned, the BNSS is concerned, section 105 of BNSS is concerned, those recoveries cannot be categorized as such as under section 105 of the BNSS. That's the limited point I am trying to make over here. This is not recording here. They are not taking about a copy of that also. I think we need to understand. They say that such recording will have to be forwarded without delay to whom? The district magistrate, sub-divisional magistrate, or judicial magistrate of first class. So many people thought that why district magistrate and sub-divisional magistrate when judicial magistrate? We understand from the court we obtain such warrant, etc. In that, as I said, in the beginning of the section 105, it is written that such as done under this chapter. If you see the entire chapter, then there are many such sections which I have listed here in my slide. But obviously, the legislative intent here is that from which authority you have issued the such warrant. If district magistrate has given you the such warrant, then we'll send the recording to him. If SDM gives you the search warrant, then we'll send the recording to him. And obviously, if the search warrant has been obtained from the judicial magistrate, in that case, our recording will have to be provided to the judicial magistrate. This is the section 107 BNSS. It was being discussed that what new powers have been given to the IOs in order to enable them doing effective investigation which are not there in CRPC. So if you ask me, this is the new section because there was no corresponding section in CRPC. This particular section gives very good power to the IO, and what kind of power does it give? Particularly if the investigating officer is investigating an economic offense, if he is investigating financial crime, in which proceeds of the crime, and which those proceeds of the crime happen to be immovable properties in particular. So you will see that in CRPC during investigation there was no corresponding section to attach immovable properties immediately. IO did not have the power. If it has to be done, then there has to be a separate special law for it, which is called Criminal Law Amendment Ordinance 1944. And the process in that is very complicated and cumbersome. Under the law, first you have to obtain permission of the state government. Then you can make application only in one court, that's the district court of the district judge. And the rest of the process is also very complicated. Looking at all these practical difficulties, this issue has been solved very well in the new law. What is the new law? First of all, now there is no requirement of seeking permission of the state government prior permission. Who will give the permission? Permission will not now be given by the superintendent of police or the commissioner of police. So you have to take permission from your authority. Second, change now. I need to make an application as an IO. I don't have to rush each time to the court or the district judge. I can now make an application in my own court, that is the court having jurisdiction to take cognizance. Simply put, where I will file my FIR of the police station. The FIR that I am investigating, I have to make an application to that magistrate. And that process has also been streamlined. If the magistrate is satisfied, then immediately he will give notice to the person whose property is in his possession. If there is an unknown property, then he will also give notice to that person. And in 14 days, he will have to file a reply to a show cause notice. In 14 days, if that person doesn't reply, in that case, an ex parte order can be issued by the court. What is written further in the subsection 5 and what is written further, that means till trial is concluded. It means that even ad interim attachment order will also remain in force till the trial is concluded. Because further, they have written in subsection 6 that after the trial is over, if the magistrate or the court feels that the property that was attached or seized is indeed a proceed of crime, the court shall direct the district magistrate to readily distribute such proceeds of crime to persons who are affected by such crime. Obviously, the victim and other persons who are affected by this crime will be informed by the court in their order, who all are affected by this crime, and it will be the duty of the district magistrate, and they have given a timeline for that within the period of 60 days from the date of receipt of this order. The district magistrate will take the property in his possession, auction it, and the proceeds will be readily distributed to persons who are affected by this crime. So the victims will get some kind of additional compensation over here, as we can see. Now, this I think has already been debated. I did not agree. Again, devote much time because of the paucity of time. I'll tell you the main things here. Everyone knows what is zero FIR and how it will be registered and who will transmit it. Electronic communication will also register the FIR, but there is a condition that it will be taken on record when the person will come and sign it in 3 days after giving the online letter of complaint. The importance of the police chief is here because here you will have to issue guidelines. It should not be the case that different police stations are doing different practices. Any police officer will think that he will come to the police station and sign it in 3 days, then only I will take it on record. What kind of information is it? What is its nature? Whether the police will have to take proactive steps to contact the person who has sent the communication, first of all. How will that communication come to you? Will the OTP be authenticated? Will the Aadhaar card be enabled? Will it come through the website? Will it come through email? Will it come on WhatsApp? Who will decide these modalities? Law does not write anything about it. They are to be decided by the leadership so that there is uniform application of this particular provision throughout the state. So I would request, I am sure by now it is possible that you have also issued it. But I think it is appropriate to say this here, this P, the primary inspection, as has already been discussed. Firstly, this is an enabling provision. It is not a mandatory provision, it is a discretionary provision. What is written in cases where punishment is more than 3 years or less than 7 years, now the SHO has been given the discretion considering the nature and gravity of the offence. If the SHO is of the opinion that I first need to conduct a preliminary inquiry, why? To ascertain whether there exists a prima facie case. So, with the permission of a senior rank officer who would not be below the SP, taking permission from him within a period of 14 days, he will have the right to do this preliminary inquiry. That is not mandatory. But in this, I believe that if we leave the matter in the letter of Lalita Kumari, the letter is a little different. But if we hold the spirit, then obviously registration of preliminary inquiry should be an exception. Registration of FIR should be the rule, and the guidelines that were given in it. And if the information is sketchy, ambiguous, or there is a matter of some specific categories of matrimonial disputes, or there is a matter of trade dispute, or there is a complaint of corruption, or there are information that has come to the police station with an abnormal delay, then this is my opinion. It is just a suggestion that I think by and large we should follow the spirit of the apex court in Lalita Kumari when we issue guidelines to our officers. Sorry again then. I think the leadership need to intervene because it should not be left totally to the discretion of the SHOs. Otherwise, in different police stations, you will see different practices. So, to rule out the thing a little to bring uniformity, it is necessary to maintain discretion. If we give broad guidelines to our officers, then these are the cases in which you may consider first doing a preliminary inquiry. Otherwise, by rule, you should do a FIR if the information clearly discloses commission of a cognizable offence. This is a little additional duty in non-cognizable reports also. Now we will also have to tell every fortnightly magistrate that in which 15 days non-cognizable reports were filed at your police station. This requirement was not there earlier. It has come in a new law. The section 175 BNSS is important because two important provisions have been made in this which are not there in the old act. 175, which is equivalent to 156, particularly in subsection 3 if you look at it. What was 156.3? That if your FIR is not registered in the police station, you have also complained to the SP and still your FIR is not registered, then you could go to the magistrate, make a request for issuing an order to the police station for registration of FIR. To prevent its misuse, there was a ruling of Supreme Court in 2015, which is called Priyanka Srivastava versus State of UP. In that, they issued directions for the magistrate that until you do not order, there should not be an affidavit with the application. In that affidavit, the person should declare that I went to the police station earlier, that is its proof. I had also sent an application to the SP, that is its proof. Despite that, my FIR is not registered, and after that, the Supreme Court said that along with taking this affidavit, you should also do some necessary inquiry to satisfy yourself whether what is written in the affidavit is true or not. And only after satisfying yourself, you should order the police to register the case. In this, a new thing has been added in the new law, maintaining these two conditions, which the Supreme Court had written in the Priyanka Srivastava case, that during the inquiry, the magistrate will also listen to the side of the police. They will seek a report from the police officer whether this person had actually approached the police or not. If he had approached you, then why did you not file a case, or what action did you take? So after listening to the whole side, it will now be kind of a well thought out order of the court. Fourth, what is important for all of us, the new addition, subsection 4, because there are only 3 in 156, in 175. A fourth subsection has been added. It is particularly relevant for the police officers, because there are many such cases during police operations when the police use force, or the police arrests or searches against a person, or takes any action. Then many times the motivated people to discourage the police try to file false cases against them by taking orders from the court. In this, they have written, if in a case against a public servant, that is, you have an application with this request that this public servant has committed a crime during discharge of official duty, so you order to file an FIR against him. Then in such a case, a condition has been put. Before ordering the magistrate, first the public servant will get a report from his superior officer, a report of the fact-finding inquiry type, in which his version will be asked. And what do you have to say about this complaint and about this incident? Second, not only that a report will be sought from the superior officer, in fact, the concerned public servant will also be provided an opportunity of presenting their side of the story to the court before the court issues an order. So I understand that it is a very important safeguard so that people can exercise their duties, discharge their duties without fear. So keeping that in mind, two very important safeguards have been done here itself. I'll tell you that in the form of a complaint case, the corresponding section, which was 200 CRPC earlier, the corresponding section is 223 BNSS. So under that section, if the person approaches the court with the necessary evidence to take cognizance and initiate action against this public servant on the similar ground, there is also the same safeguard has been provided in that section 223 also. That before the court takes cognizance on such a complaint, it will have to first obtain a report from a superior officer of the police IO, or also provide the concerned public servant the opportunity of being heard. So these are the safeguards. This 176, which is corresponding to 157, in this also they have made some important changes. In the case of the victim of rape, it has been stated that its statement can be made through audio and video recording. And the second thing is that is very petty cases. If you have decided to close the investigation, you have decided to close the matter without doing any investigation. In such cases also, the SHO will have to send a fortnightly report to the magistrate. But what we have already discussed, that 105, when we were discussing, that is written in subsection 3, in the cases where the sentence is more than 7 years, the date on which the state government will notify, and for that, the state government has been given 5 years' time. And on that date, it will be compulsory in each and every case to send a forensic expert to collect forensic evidence on the spot. His videography of this process on a mobile phone or any other electronic device will become mandatory. So let us be very clear about the difference between 176 and 105, which we have discussed in detail. What is important here, which again is the power of the SHO to collect oral evidence to any person. 160 CRPC, the corresponding is 179 BNSS, can give notice. As we already know, there are certain categories of persons who are exempted. They cannot be called into the police station for the purpose of examination. In 160 CRPC, there were 4 categories of persons. Any woman, any female of any age cannot be called. Male children below 15 years cannot be called. Elderly persons above 65 years, male persons in particular, they cannot be called. And persons who are mentally and physically challenged, they can also not be called. So the first thing is what has been changed in the new law. What has been changed in the new law? There have been 2 changes. What is the second change? This new provision, that is the one. More important is the new provision that has been added in the section. Here they have written that any person above this category, if that person himself or herself makes a request to the IO because they have to express their willingness to attend at the police station, in that situation, such person may be permitted so to do. So here I always caution the police officers that before you exercise the powers, newly given powers under this provision, please you must know that if we call any person in violation of the direction of law to the police station for examination, it is a cognizable offence. Earlier under section 166A of IPC, Now the same offence has been retained in section 195 of BNSS. Not only that, what is the second problem? In that, for an offence under 166A of IPC and 195 BNSS, you will not get any protection under section 197 CRPC and corresponding 218 BNSS. What is the meaning of this? There is no requirement of seeking prosecution sanction for prosecuting an officer under section 166A IPC or 195 BNSS. So what difference does it make? Why I am saying the habit of a police officer is that they work with their mouth. The person has requested you on the telephone. You have accepted the request on the telephone and said, okay, you come. Mostly what you do is, you will put a note in the case diary. My opinion is that sometimes it cannot be sufficient. You are safeguard. If that person turns around tomorrow and puts allegations on you, so what will you do on request will be, please ask the person to send you an application in writing, either by physical form or electronic form by email. And you should also inform in writing that, okay, orally keeping in view your application for this request, I am allowing you on such and such a date. Now you may visit the police station for the purpose of examination. Means you should have necessary safeguard. This is very important, particularly in view of the issues that have been raised. As far as section 164 CRPC is concerned, you will note two important changes in it, which is related to the recording of confessions and statements. Firstly, its scope has been restricted. Mostly, it has been increased, but this is one section which applicability has been reduced. In the sense, what was there before in section 164, that if you have to get a statement of any person, then you can get it done in any court of India, no matter where the case is, no matter where the registration of a affair has been done. If you have to register a case of a person from Hyderabad in Delhi, then you could have done it in Delhi's court. That has been limited. Any court of the district where the affair has been registered, no court in the whole of India can do it. The second important change from the point of view of the police is that in serious offences which are punishable with 10 years or more or with life or death, if now a police officer will make a request to the magistrate to record a statement of 183 BNSS, now the magistrate will not be able to say no because it has now been made compulsory, mandatory for the magistrate that the magistrate shall record a statement of such witnesses. So these are the two important changes from the point of view of the police. Here they have given a time period of 7 days in this section, particularly for furnishing the medical examination report of a rape victim. I believe that in most of the states this time limit is very less. Like I can say for Rajasthan it was less than 24 hours. So we were already getting such reports in our state within a period of 24 hours. I understand that many states have made the request to MHA again to amend the provision and reduce the time period below 7 days to bring it down, I think. Because in a rape case, particularly in a sensitive rape case, I don't think you can afford the doctor to take 7 days to providing you the medical examination report. I think getting medical examination report within a period of 24 hours is quite crucial for investigation of rape cases. So I think I can make a note of it in the state. We have already discussed this. Here they have made only one change, that you will have to record reasons. Why do you think that you need to immediately conduct searches without obtaining a warrant from the court? In that case, earlier the document where we have to record reasons was not specified in the new law. So they have specified that you will have to record your reasons in the case diary. This is the only change. We have already seen that the search that we will do will be recorded in the video. Regarding the police remand, I don't think there should be any confusion. There is already clarity in this. Earlier, Supreme Court had put a restriction in Anupam Kulkarni vs CBI case, which came in the year 1992. It was written that after arrest, within the first 15 days, you can obtain police custody, and from the 16th day onwards, it can either be judicial custody or release that person on bail. So the first 15 days timeline, the time limit imposed by the Supreme Court in Anupam Kulkarni case, by removing it, by extending it, because there are two categories of offences which are covered in this section. Offences which are punishable with less than 10 years, offences which are punishable with more than 10 years, 10 years or less, and more than 10 years. Accordingly, the 10 years or less category of offences, the time limit has been increased from 15 to 40 days. In the more than 10 years category, it has been increased to 60 days. So what is to be noted here? That the total period of police custody has neither been reduced nor increased. It stays at 15 days. Secondly, they have clarified, which was not there before, that it is not necessary to obtain the full and the entire 15 days custody at once. You can also take it in parts. This is one thing. Thirdly, it is written that to obtain the period of up to 15 days, the request you will make will be for the first 40 days, within the first 40 days. If the crime is less than 10 years, punishable if it is more than 10 years, in that case you can make this request within the first period of 60 days from the date of arrest. The rest is same. The clarification they have issued in a way by provisioning the corresponding section of 170 CRPC, 190 BNSS, that when we have to file charges against a person in the court. Suppose you have not arrested that person during an investigation. It has been made very clear that when the section 41A notice, because of what was written in that, so that during this stage, when that person appears before you in response to the notice under section 35(3), that you shall take security from such person, that he will appear in the court as and when you will be called upon by the court. In which form you will take security, you will see this form is also given in BNSS. So you don't have to bother even about that. They have given the form also, in which you will obtain security from the such person, guaranteeing his presence. If you have obtained security from this person during an investigation, in response to this notice under section 35(3), in that case, you will file charges along with the security, and the magistrate shall not refuse to accept the police report on the ground that the accused is not taken in custody. So the ambiguity in 170 CRPC regarding this matter that has been removed well in corresponding with the section 190 BNSS. I think now there should be no confusion on this particular point. This is your section which is related to filing charges under section 173 to 193. In this, 2 to 3 important changes have been made. One is that whether you have maintained the sequence and integrity of your electronic evidence, whether your chain of custody was proper or not, you will have to write that along with your police report. The second important change is the victim point of view. What is the new for the victim in the new law? We have seen many things. The section related to FIR have already come up, but here an important section is that victim will have to tell the police that what is the progress of the investigation you are doing. Now it has been made a legal right of the victim to know the progress of investigation from the police officer. So here you will have to change your attitude and habits. Plus, once again, suggestion. Please, here comes the role of supervisory officers of the leadership. Again, it should not should not be that one police station is writing this. When they ask what is the progress, you tell them, then we are doing investigation. Investigation is continuing. Investigation is on. This is no information. They know that the investigation has not yet been concluded. So the point is, how much will they tell? What will they tell? What information will they give? What will they not give to maintain uniformity in the entire state? My suggestion would be to issue, I think, guidelines. What exactly is the information that we will provide to the victim when the victim or the informant shall ask us about the progress of investigation? Last point is important. In 173 subsection 8 used to end, as we all know, 173(8) gave us power to continue further investigation even after filing the police report. That provision has been retained. Those powers of the police have been retained, no change. But they have added a new proviso in the new section 9, which is corresponding to 173(8). If you intend to continue further investigation or you intend to initiate further investigation during trial it was not there here. Here they have said if you want to continue further investigation, then you require prior permission of the court, and they have put a timeline. You have to finish it off in 90 days, which may be extended with the permission of the court. So keep this in mind. First, there should be clarity about the date of trial, on which date we should believe that the trial has started. As we have discussed earlier, on which date the court charges and given an option to the accused to either plead guilty or to face trial. Generally, the accused selects the option to face trial. On that date, the trial begins. Prior to that, the proceedings are not considered to begin. They are the pre-trial proceedings. Prior to that, the court can discharge the accused, because either they apply the discharge application or frame an argument on charge is going on. During that time, you are not able to satisfy the court that you have sufficient evidence against a particular person. Court has the option, instead of framing charges, to discharge the accused at this stage itself. That's why the trial has not started yet. Court has not decided to initiate trial. On which date it will decide when the charge will be framed, and the accused will say, I don't want to plead guilty. What is this for witnesses? What has been made in the new law for witnesses? The most important thing that is given in the new law for witnesses is that now you need not go physically to the court for the purpose of giving your evidence. Again, it will depend on the state government, because a witness is a normal person. You cannot expect a witness to join the court proceedings from his or her own mobile, because that may not have the state-of-the-art facilities. That's why it has been written in the next section. There will be more clarity here. It will be responsibility of the state to make designated centers in different places, when there should be the facilities of state-of-the-art video conferencing. And it should be convenient to connect to your court. If you have made such designated center in your state, then it will be your duty to notify the nearest center witnesses that this facility is available in a particular place. You will reach there on this date, and it will be deposited through audio, video, electronic means. Deposition is EIV means. So I think whether you are a public servant as a witness or you are a normal person as a witness, What has been emphasized a lot in the new law is please don't insist for their physical presence in the court. Sometimes witnesses travel such long distances, and after going to the court, it is found that there will be no evidence today. Either the judge is on leave, or there has been a strike of lawyers, or for some reason this matter has not come up on the board. It has already ended, and you will have to come to the court again after 2 months, 3 months, 4 months. So, to save this inconvenience for witnesses, it has been repeatedly said in the new law that please don't call them physically to the court. Please provide facilities. State must provide facilities where the state witnesses can be taken to the nearest center, having such facilities from where they can depose in the court through audio, video, electronic means. Like this session trial case, here you can see in the warrant case, they have written this thing clearly. Examination of a witness may be done by audio, video, electronic means at the designated place to be notified by the state government. I want to say that when you are writing for a warrant case, then you should have written the same thing for session trial case. If it is not written, then that doesn't bar the state government to create such facilities. Because what has been written is that even in session trial cases also, witnesses will be able to depose through audio, video, electronic means. So that you use this facility for a warrant case, same facility can also be used for the trial of sessions trial cases. Here again, the same thing is witnesses. But these witnesses are of special category. These witnesses are public servants. As an expert, they are experts like forensic experts. You have so many medical examinations. You have medical officers. So these people have 2 to 3 big difficulties. Your work is also delayed. One is that they go to the court again and again to testify in their old cases, so you don't get it at all. You go to the forensic expert and ask him to quickly examine your exhibit. He will find out that it is appearing in court every 2 to 3 days. So to save this time, to save this facility, what are the new things they have added in the new law? Because you can appreciate it is a new section. There is no corresponding section in CRPC. 2 to 3 things. First of all, a rider has been put a condition. First of all, the court has to ask the defense in particular, do you dispute the document or report prepared by this public servant or expert? If there is no dispute on the document, there is no requirement of getting the document proved or exhibited in court. So the matter is over. So one is saying that if there is no dispute, then there is no need to call the witness who prepared this document or report. The second thing is that if he disputes and needs to examine that person, then what they have written is if such a person has been transferred or retired or died or cannot be found or incapable of giving deposition, maybe due to medical and health reasons, and securing their presence would cause delay. Many times such people go abroad and sit with their children. So they are very reluctant to come from abroad. So there is a lot of delay in this. So what was the new law written? The court shall secure presence of their successor holding that post to give deposition on such a documentary report. You forget that original person. Instead of that, the person who is working on that post today, public servant or expert, work from his deposition. Third thing, do not physically call him to the court. You may allow examination through audio, video, electronic means. So these are the precautions. One more thing about witnesses, we will see that. This new section also empowers the IOs. There is only one issue in this. There was no provision in the previous law that if a person refuses to give finger impressions or voice sample voluntarily, when you ask that person to provide you voice sample or a finger impression, then you may approach the magistrate and request the magistrate to issue an order to such person for providing their finger impression or voice sample. There was a court ruling, Supreme Court ruling on this known as Ritesh Sinha versus State of UP case, the decision that came in 2019. Keeping that in mind, this has been incorporated in the new law. And one more rider or a condition in the old law that the court can only issue order for those people who are in custody. That condition has also now been removed. And it is written that it is not necessary to issue such an order that that person should be in police custody or should be in custody. Word is custody, not police custody. So that is why without him being arrested without arrest, when you can do the entire investigation without arrest, then only to take that person's voice sample or to take finger impressions or to take a specimen signature or to take handwriting, we arrest that person without feeling the need. It has been provided in the new law. It's again a very, very important change that has been made in the corresponding section of CRPC for 97 BNSS disposal of your seized articles. Malkhana items, which you can call popularly this. In this, they have written very clearly that most of the articles can now be disposed of during investigation itself. This is important because this word investigation was not there in the corresponding section of CRPC. This has been added in the new law very clearly that during investigation itself, if you will make an application to the court, then please prepare a statement containing description of the property, but in a manner provided by the state government by rules. So again, I think some responsibility has been put on the state government to prescribe rules in the manner in which the statement shall be prepared containing description of the property. Then once the statement is prepared, then the second direction of the court will issue is that now do photography of the property which you want to get disposed of. Videography is optional, photography is mandatory. It further says the statement containing description you have prepared, photography you have done, will exhibit this property on its basis. So you don't have to keep this property in physical form, and therefore now the court can order disposal, destruction, confiscation or delivery of the property within a period of 30 days. So my request would be, law has enabled you. Now even after this, you can keep old properties, vehicles badly damaged in an accident in the form of trophies and keep them in the police station. That is not necessary. The badly damaged vehicles which no one will take, insurance has also claimed it, everything is done. It is not known who owns it and who does not. Such iron and wood can be disposed of, auctioned, and whatever money comes, deposited in the state treasury in future. If the court gives an order in someone's favor, then the amount of money you have deposited, that amount will be ordered to be given to that particular person. So most of the stuff that we now keep in our malkhana or the police station, it appears to me that will use this provision which has been given. Then we will be able to dispose of many such items from the police stations. Last but not the least, section BNSS, what it says, this is at a new section where they have been given emphasizing use of technology, audio, video, electronic means. Sum it up. In simple language, if I say this, then why they say, what is the legislative intent over here? That is, if during an investigation from the police point of view, I am taking because it extends to the courts also. The similar offer is extended to the courts also. But from the police point of view, they say anything which you think could have been done by use of technology, by audio, video, electronic means, and we may have not made a specific provision in the corresponding section, then please use exercise powers under the section. Refer to section 530 BNSS. And if you think that something can be done by use of technology, go ahead and do it. So you can say this all-encompassing section which enables the use of technology in all kinds of proceedings, either relating to investigation, trial, inquiries. So this was very important. 531, we already know. There are doubts about the applicability of 531-2. Already, different rulings have come from different high courts, even in the old cases. That in the old cases which are going on, in which case will CRPC be applied, in which case BNSS will be applied. The High Court has given a different order. Rajasthan High Court has given a different order. Punjab High Court has given a different order. Kerala High Court has given a different order. Obviously, ultimately this issue will reach the apex court and they will have to come out with either the legislature or there will be clarification issue in the legislature, because this also I think needs to be flagged to the MHA or the Ministry of Law, or I think the matter will have to reach someday to the apex court, because which court's decision is right, I think it's not possible for us to comment. We cannot say that Delhi High Court has said is very good, Rajasthan High Court said is not that bad, because these court rulings have come. That's why keeping this in mind, because there is a lack of time, that's why I won't be able to tell you in detail. I will only say one important thing about Evidence Act in 2 minutes. There are only two important changes according to me. There are many other things. One is that they have cleared that anything related to electronic evidence, electronic communication, the value that we used to give to the document, the importance of a document as far as admissibility of evidence is concerned. So they have clarified that clearly that now the electronic information will also have the same value as far as the degree of admissibility of evidence is concerned, which you have given to the physical documents till now. Firstly, they have said this. Secondly, by expanding the definition of primary evidence, they have tried to say that many such recordings, which we used to consider as secondary evidence, now they will be treated as primary evidence. So if you start considering it as a primary evidence, then you will not need to take the certificate of section 63 in order to make such evidence admissible to the court of law. In primary evidence, you don't have to have a certificate. They have also expanded the secondary evidence separately. But the section 63 of electronic secondary evidence is important. You should also know that you may face some practical difficulties with it. And my request would be for the leadership here again to flag these difficulties through your state government to MHA. Only then MHA will change it, because what is section 65B, which was the admissibility of your secondary electronic evidence, that we used to take the certificate of the section 65B and the present the secondary electronic evidence in court, which is to make it admissible on the basis of that. In the corresponding section 63, now there are two requirements of taking two certificates instead of one. In addition to the certificate that you would take under 65B, that is the certificate from the handler of the machine, now there is an additional requirement of also seeking a certificate from an expert. So I believe that the feedback I am getting from most of the states, the feedback coming from the central agencies, so far no state has been able to tell me satisfactorily that they have defined such experts properly, identified them and notified them. In every secondary electronic evidence, they are collecting the new FIRs. They are obtaining Part B as a certificate from this expert. There is also an issue of hash value in it. Particularly, if I give one example, CDRs, all detailed records which you obtain from the service providers, and we all know it runs into thousands every day. If we take a comprehensive look at all the CDR requests which are made by all the police stations of the state, so how will you obtain a certificate of the expert in order to present the secondary electronic evidence in court? Who will give? Who will note the hash value of the Part P and CDR? How will it be noted? So all these difficulties that are coming while flagging them, I think a request will have to be either the state should think of making its own amendment, or, and if the state is not thinking of making its own amendment, then at least they should flag it. Because this is a national level issue, I think there is a scope of making a request to the government of India that you kindly restore the earlier position of taking only one certificate, that is from the handler of the machine. And I would further go and say the requirement of noting hash value, which was not there in section 65B, may also be done away with, because it may not be possible for each person in whose possession that machine will be, with which you take secondary evidence, will be familiar, will know how to take the hash value, how to record it. So these are some of my observations. I think I have tried, though I have exceeded. I took a little more than 5 minutes. But with this, thank you for the patient hearing. I think I can close the presentation. And very quickly, if there is a couple of observations, then I think we can attend to that. Thank you so much. The floor is open for questions. If anyone has any doubts, comments, or questions, I hope I am not sure, because this is the problem. When you address through an electronic mode, you are not able to look into the eyes of the audience. So you really do not know how they have responded to the monologue that you have made sitting from a distance. So one question, morning, yes please. Under 187 BNSS, you said that any magistrate can order for the remand. Yeah, if a CP has given magisterial powers, correct, can he order for the same kind of remand? Please read the whole section. There they distinguish between the judicial magistrate and executive magistrate. Okay, when you will read this entire section, you will come to know that this particular power is meant to be exercised by the judicial magistrate only. But the executive magistrate, whether they are a CP or a DM or SDM, they have also been given power only in certain situations when it is not possible for you to tell the accused, take the accused to the judicial magistrate. Then you can produce the accused before executive magistrate, and the maximum period of demand they can give is up to remand is 7 days. So when we read the entire section, it is very clearly laid down that magistrate does not include an executive magistrate. In fact, I would also request you to read sections 3 of BNSS, and also the first there is a problem they have clarified. What do you mean by when they say any magistrate? So they say unless we clearly specify that this magistrate also includes executive magistrate, when we say only magistrate, that means judicial magistrate only. So whenever we want a particular power to be exercised by an executive magistrate, then we'll clearly mention in the law, and as in 187 BNSS specifically, if you read the entire section, you will find that executive magistrate also have powers, but only in certain situations and only up to a maximum 7 days of police custody remand. Thank you, sir. Good afternoon, sir. This is Karthikeyan. Thank you so much. Very informative session. Sir, one thing, now there is a lot of welcoming change as far as the digital forensics is concerned. We see a lot of convenient things like recording your mobile phone and all, which actually we were doing for a long time as well, sir. Now we have legitimate basis to do that. But at the same time, sir, when we were collecting more of digital evidence, I think we are largely dependent on our forensic capacity building. Because right now we have, when we record something, a video, audio, the time we have to legitimize it, to certify it through some forensic lab. So I think there is a lot of onus on the forensic capacity building as well, so that in the interest of justice, the reports come to us, because it is definitely going to be disputed. Now AI is there, modifications are there in videos, audio and all. So I think that also will challenge the poacher policing. That's my observation. Thank you so much, sir. I think you have made a very pertinent observation. That is why when I make my suggestions, one is that we must know very clearly that what is the mandate of the law, where the law has made it mandatory, compulsory for us to do the recording. Say for example, section 105, where we have already been doing it, or we want to do it as a measure of our own safety. That okay, now nobody will be able to make any kind of allegation against me, because I have got the entire process videographed. So one is, I think it is for us to decide whether we should continue this discussion, use of videography, or whether we confine it only to those where the law mandates it, making it mandatory. That is one. Secondly, I think when we do recording, we need to make a distinction. Recording per se are not evidence. Even section 105 is not enabling you to collect evidence. Certainly not, because when I do the videography of the such process, this by itself doesn't help me. as far as the proving guilt of the accused person is concerned. This per se is not an evidence against the accused person that you know. When I went to his house, I seized this, whatever. In fact, even without videography also, there are other ways of proving what has been seized. You can prove that to the court. Then why it has been prescribed, I think, only in order to say, one is that in order to enforce accountability, responsible behavior, because now we know, now it is mandatory for us to do the recording of the entire process. Then obviously, complaints of abuse of power or misuse of power by police, which used to flow against the police officers, will no more be there. So I think the legislative intent here is to reduce the possibilities so that the police will behave more responsibly. They will be more accountable. Section 105 per se doesn't empower you to collect evidence. Evidence will be what we get in search. You will get some incriminating material. You will get a document. You will see some digital evidence from these computers, mobile phones, something like that. Evidence is that. This recording per se is no evidence. So I think whenever we do any recording, we need to. Why would we send an expert? Do we need to get it analyzed by an expert? As far as I understand, we get it analyzed by the expert in which there is a possibility of incriminating material. If you read section 105 properly, then what does it say? As soon as you do the recording, who will you send the original recording to? To the magistrate. There is no scope of sending this recording to any laboratory because that is not its purpose. It is just to safeguard. It will stay with the magistrate. In fact, if you ask me, this recording that we will do, which will go to the magistrate in the original form, which will not even be given to the accused under section 193. It is not covered under section 193. If that man disputes that no sir, he did this, he did that, if someone accuses, then it is the magistrate discretion to take the help of that recording and decide that accusation. What is the legislative intent? We also need to understand this thing well. Thank you. Thank you, sir. In continuation of the previous point itself, regarding the video recording of search and seizure, sir, in relation to scene of crime. Sir, as you told, examination of scene of crime under section 176. But any seizure made at the scene of crime should be interpreted under 185, sir. Not necessary again. Examination of, you see, it has been mentioned in 176 itself. Why do you examine a scene of crime? Obviously, whatever incriminating material or a thing or an article you will find there, it has to be seized. Section 165, now 185 BNSS, you see, it comes into play much after registration of the FIR, whereas section 157, 154 were there earlier. Now, if you start from 173, 173 FIR, 174 knock-knock visible reports, 175 power of magistrate to order investigation, 176, you understand, FIR is registered. Where you start the investigation? What is the first step given by the law? Please go to the scene of crime and collect necessary evidences from there. We have not yet reached section 185. We have not reached the old 165. It is very far. Before that, the law has mandated that as soon as the FIR is registered, you go to the crime scene and seize whatever incriminating material you find there. If you ask me, these seizures are not covered under 185 BNSS. That is why it is written there. The provision are put by the new forensic expert. What is written in it? If you have committed more than 7 years of criminal offense, then it is mandatory that you send an expert. But since there is no such facility in all states, they have given a window of 5 years to states that you create these facilities and within 5 years you notify making it compulsory. Then they say an expert will go, who will go on the spot and collect the forensic evidence, or you have to videograph the process. It's a matter of videography. Then they have clearly mentioned which thing is mandatory to videograph. So if you ask me, neither the provision of 105 nor the provision of 185 would apply on both the examination of crime and whatever you seize from there. No. I think again, we have to be very clear. You see, if you read again, you will have to read it with section. Section earlier was 161. Now corresponding section is 180 of BNSS. If you read it carefully, you already have the description earlier also. When you examine a person, you are now not sure what this person is going to tell me. The notice that you send under 160 CRPC, now the corresponding 179 BNSS. What is written there? You seem to be acquainted with the facts and circumstances of the case I am investigating. Therefore, I need to examine you. Please appear before me. I don't know whether you really know, what you do not know. Whether that would be relevant or irrelevant for the purpose of the investigation that I am making. I will know that only after talking to you. So, section 161 CRPC, the corresponding section is 180 BNSS. What discretion does it give you as an investigating officer? First, let us listen to this person, what he has to say about the issue that I am investigating. If in the examination he tells you something relevant and you feel now I need to make this person a witness, therefore I need to reduce what he is stating in writing. So there is a discretion left to the investigating officer. It is not that you have to write the statement of every person that comes in front of you in writing. This is already there, same thing is maintained. Now, what is the new addition as far as the use of audio video means for recording is concerned? He says, if you want, this process is only facilitated by distant recording. Listen carefully. One is that you are seeking physical presence of that person, that you come in front of me, sit here and tell me. One that you now need not insist for physical presence of the witness. Before, you can examine the witness through audio, video, electronic means. Rest of the provisions are the same. That is your discretion. If you want, you can reduce it in writing. But if you want to use the person as a witness, you think that this person is giving me some information which is relevant for the case, you will have to record the statement in writing. The audio video recording is not the statement under section 180 BNSS, which you used to write in section 161, and you used to write read over and accepted as correct. Same formality you will have to do. Because what will go to the court? The written statement will go to the court. New law gives you only this facility, that instead of physically calling the witness and examining him, you can examine him through audio video means. That is the